Which is the order passed on SLP?
Yes, sir. That is why I could not get the order.
Yes?
I could not get the order copy.
All right, come tomorrow. Tomorrow.
With your lordship's kind leave, my lord.
But this is the writ appeal, my lord.
Serial number 49.
But may I, with the permission, my lord, I apologize. There was a technical glitch in the camera.
Rebuild the structure which was originally ordered to be removed under the guidance and even the watchful eye of acute the mapping for the company.
Yes.
Lordship can have it done.
All right.
My lord, serial number 20.
You want it today?
Please.
All right.
My lord, serial number 25, my lords, list 1.
Yes.
Parties are exploring settlement, my lords. So the matter may be kindly attended.
Lords, I appear for the respondent in this matter. I'll be filing my wakalat today.
Learned counsel for the parties state that the parties are attempting to resolve the disputes amicably. This is Namo Organics.
My lord?
No, my lord, Sun Large.
25, my lord, Sun Large.
Seal number 25 of list 1.
25.
Sun Large Industries Private Limited.
All right.
My lords, one writ petition. One writ petition which was heard, and there was an interim order also which was passed, my lord. But thereafter, my lords, it was dismissed for non-prosecution, but it was restored very recently by my lords. And while restoring, my lords, by oversight, the interim order has not been restored. So it may be again heard and may be kindly posted for.
Put it on application. File your application. Yes.
Friday, my lords.
You have to file your application. You file your application, we'll take it up.
Lord, serial number 25 again, my lords, I apologize.
Please,
Serial number 25, which was just adjourned, the timeline may be fixed, my lords, because of settlement. For 2 or 3 weeks.
We've given a date.
Great. Apologies.
Yes.
My lords, serial number 31 in the first list, my lords.
34.
31.
Please wait, sir. Is he...
34, a request for adjournment is made by the learned counsel for the petitioner at his request this term.
15th of June.
It's a fresh matter for posting, my lords. PIL matter. It was listed last week. Bona fide mistake on my part. I was on my legs in another court. It's adjourned to 4th of June, my lords.
You move an
request for any.
You move in separate application.
Yes. But I then move it, my lords, after filing a
When you move it, it'll come in 4 days. We'll take it.
This is a fresh matter. I am an hostel warden. I was terminated from the services. Challenging that, I preferred an appeal under Karnataka Education Act before the tribunal. There, the question of maintainability was raised. The trial court and the learned tribunal answered in affirmative, challenging that thereafter the respondent preferred a writ petition, where the learned single judge reversed the order, saying that the appeal is not maintainable. I have challenged that and have come before this court under a writ appeal. The urgency is that day after tomorrow, the trial court, the matter is listed before the trial court. The Lordship may kindly have
come in 4 days' time. Put it there.
It today, Lordship, but the date is on.
You tell them that this matter is pending. So they will come in 4 days' time.
My lord, it's a mining matter, my lord. There was a application for the installing of a crusher unit within the buffer zone. I objected it. Now they have dug up a trench to my only access road, my lord. And they're not letting me.
It will come in 4 days' time.
Right? Lordship, serial number 40, my lord, first list. Lordship, kindly have it day after tomorrow, my lord. The construction is going on. Petitioner land is concerned.
What do you want? You are for the petitioner?
Petitioner, my lord.
We'll take it today if you want.
Please.
There's some urgency.
Please.
Serial number 30, my lord, and for the appellant, I have informed the other side, my lord, a week's time, the arguing counsel.
My lord, the urgency in this matter is, my lord, till now they have not issued MQRL, my lord. The students are suffering, my lord.
My lord, next week, my lord. Arguing counsel is not well, my lord, today.
Short accommodation, my lord. Short.
Request for adjournment is made by the learned counsel for the appellant. It's stated that he is not well. Put it after some 7-8. This month only. Put it.
12th of March.
12th. Yes, with permission, my lords, may I mention a fresh writ appeal, my lords?
Any other mentioning?
It's item number 23, my lords.
Yes.
And so on the last occasion, I made a mention that there's a settlement talks going on. It's at the final stages, my lords. It's my grant to short date, my lords.
The respondent members.
23. That was a case on 28th January also.
Please, man.
1 month ago, you took it on the same ground.
It's at the final stage. The respondent side advocate is also here.
A request for adjournment. Once again, a request for adjournment is made on the ground that the parties are attempting to resolve the dispute. Joint request is made.
So 11th of June.
Please, sir.
List 1, serial number 19. I'm appearing for the accused. Learned single judge has stayed the matter. Kindly a short accommodation for 2 weeks, sir.
Learned single judge
has stayed the matter.
You're for the complainant? Accused?
Yes.
If it's stayed, then you tell us. If you're stayed, we'll close the complaint.
Kindly a short accommodation for 2 weeks.
If the order disobedience of which is complained is stayed, we'll close the complaint.
Senior is out of station, so kindly. Obliged.
Where is the complainant?
Ashwin.
Or wait, you wait. You wait. You are for the complainant. He says its order is stayed.
Today morning it's
Then we'll have to close the complaint.
Yes.
19.
The
learned counsel for the parties state that the order, the disobedience of which is alleged, has been stayed by the learned single judge. In this view, the present complaint is closed with liberty to the complainant to revive the same, subject to revive the same if a cause so arises. Revive or apply afresh if a cause so arises.
Any other mentioning?
Serial number 31.
I appear for the appellant in it matter.
Serial number 31.
Please, my lord.
Yes.
Time for respondent number 4, my lord. I request a week's time, my lord.
Who's appearing for the
I appear
appellant?
for the appellant, my lord. No objection.
Request for adjournment is made on behalf of the learned counsel for respondent number 4. The appellant does no objection. Learned counsel with the appellant has no objections to this time.
Serial number 14, I appear for complaint.
Great.
The respondent is present before the court. He is seeking for some time for filing the affidavit. He was seeking for some time. Serial number 14, first list.
Lords, may I mention, my lords, with the permission?
A request for adjournment is made on behalf of the learned counsel for the accused. List
1, serial
2nd April.
List 1, serial number 61.
May I mention, my lords? May I mention, my lords, a fresh rate appeal? Lots of fresh rate appeal, my lords. Already filed on 10th February, my lords. Object.
61 is?
61, I'm for the appellant.
Yes.
We filed an IA for production of certain documents which we procured only recently. Lords may have it after 2 weeks. The other side is
Request for adjournment is made on behalf of the learned counsel for the appellant. List
11th of June.
Fresh matter, my lords. Counsel is on VC.
Yes.
Fresh matter, my lords. Office objections have been complied.
Not with permission.
25th we had complied.
It will get listed in 4 days time automatically.
Lords, 10 seconds, my lords. My lords are already indicated on the last mentioning that it will be listed in 4 days. My lords have an office order, my lords, complied by 25th February. Till date, my lords, not listed.
Just take.
Not tomorrow, my lords, if possible, I'll come physically, my lords.
You'll find out. You'll get listed.
Any other mentioning through VC, sir? List 1, serial number 13.
For the complaint, the matter has become infructuous. The writ petition order has been challenged in a writ appeal, and the order has been modified. May be disposed of infructuous with liberty.
Complainant submits that the complaint has become infructuous as the order, the disobedience of which is alleged, has been modified in appeal, in appellate proceedings. The complaint is next paragraph. The complaint is accordingly closed.
Please. 14 adjourned. Serial number 15.
Please, my lords, I appear on behalf of the complainant, my lords.
My lords, appearing on behalf of the accused.
Yes.
Looking
My
for
lords,
a short
this-
accommodation to file a counter to the contempt, my lords.
Please. My lords, this complaint has been filed as against the interim order passed by.
Anyway, let her file an objection. Then it
Please,
counsel if the accused seeks time to file a statement of objections. Let the same be filed within the period of 2 weeks from date list.
Grateful, my lords.
6th April. Seal number 16. Shrimati Leela P. Devadika.
Your Lordship, I appear for complaint. This is the order of the year 2023, Your Lordship, till today. They have not complained.
Necessary steps have been taken. Subsequently, the order passed by the Division Court of this Honorable Court in Contempt number 1183 of 23. The liberty was given for the petitioner to appear before the Tahsildar and to place the documents. Despite of opportunity, has failed to produce the documents. So the documents available in the office has been placed before the missing committee to reconstruct the documents. Lordship, may kindly see my memo of production of documents. The relevant at page number 5, my lords, translation portion and paragraph number 2. So now the documents have been placed before the missing committee. Now the missing committee is yet to take a decision in this matter, my lords. If some reasonable time is granted, I'll report back the decision taken by the missing committee with respect to the building up of the file pertaining to the petitioner cases concerned, my lords. The direction is at page number 21 of the contempt petition. The para 3 of the order in contempt says, my lords, in view of these facts, the complainant is permitted to attend the office of Tahsildar on 17/1/24 along with all necessary documents and produce the same. On receipt of such documents, the Tahsildar shall refer the matter for reconstruction of the file at the hands of the said committee and comply the order of the learned single judge with respect to body and duress work as expeditiously as possible. After the subsequent to passing of this order, my lords, they have failed to produce the document. But still the documents available in the office have been placed before the missing committee, my lords, on 25/11.
Lordship, may kindly see the next
21/11.
annexure E, Your Lordship. In terms of the direction issued by this Honorable Court, Your Lordship, where it says that, Your Lordship, I should appear before 17/1, but I could not attend on that day. I attended after 2 days, on 19/1/2024, my lord. I submitted all the documents, the annexure E, page number 22. It's a representation along with the documents, even documents also, whatever available, original documents, I placed before them.
Now the
That's at
same
page
is,
number 22, my lord, kindly see.
now the same is placed before the missing committee, my lords. The missing committee has to take a decision on this regard, my lords.
And the enclosures are there. Hangami
Just
Sarwal
24, no? Outer limit was 9 months.
Please, my lords.
9 months is long gone.
Please.
9 months, you have to finish
Now
out.
the necessary steps have been taken on 21/11/2025, my lords. Now I'll report back the decision taken by the missing committee by the next date of hearing.
21/11/25.
Please, my lords.
What were you doing for a year? Order comes, contempt order is given, that is not followed. And now when the second contempt comes to be filed, you make an endorsement and...
No, now the endorsement has not been issued, my lords. Now,
we are putting it before the committee.
Please, now the committee has to take a decision in this regard, my lords. On next date of hearing, I'll update about the decision taken by the committee, my lords. This is the latest development has taken place, my lords. That is my submission.
Latest development is not in time. 9 months is not a short period. Obviously given for you enough leeway for you to finish the work.
I'll report back, my lords, with enough.
Look at your memo. The complainant has appeared, given the documents. The memo says no documents have been given.
My lords, in the letter addressed to us, my lords, is that no documents produced. My lord. I'll verify and I'll submit, my lords, and file a complaint affidavit.
What verify? He's given you, filed it in the contempt petition. Yes, true. He's answering to this.
Please,
He's got the copy of the contempt.
I have it, my lord.
So where does he say this order is not there? This letter is not received. There is a letter. It encloses the documents. These are completely ignored.
I'll verify and place it on the next date of hearing, my lords, and also file a complaint affidavit in this regard, my lords.
I think we need to close this kind of thing around. Just take down. The complainant has filed the present complaint alleging willful disobedience of the order dated April 2023, passed by the learned single judge of this court. Whereby it was observed that the accused is duty bound to consider the respondent Tehsildar, bracket accused, was duty bound to consider the representations made by the petitioner for 4D on Darast of the lands in question under the Karnataka Land Revenue Rules 1966. Accordingly, the accused was directed to pass appropriate orders within a period of 4 months from the date of receipt of the said order. Apparently, no steps were taken in compliance with the said order. In view of the above, the complainant was constrained to file a contempt petition, being CCC number 1183 of 2023, bracket civil, alleging willful disobedience of the order dated 13/4/2023, passed in WP 8216 of 2023. Compliance affidavit was filed in the said proceedings, inter alia stating that the accused had called upon the complainant. Accused had, by a letter dated 21/11/2023, called upon the complainant to furnish certain documents for completing the exercise of 4D and Durast. It was alleged that the complainant had failed to produce the read documents. Therefore, by an order dated 6/12/2023, the accused had referred the file to Missing Files Reconstruction Committee for suitable action. Full stop. In view of the said stand, the learned counsel for the complainant had stated on instructions that the complainant that did possess the Sugawali chit and the relevant document and the revenue documents. Full stop. In view of the above, this court had directed had permitted the complainant to attend the office of the accused on 17/1/2024 along with the necessary documents. It was further directed that on receipt of such documents, the accused would refer the matter for the reconstruction of the file at the hands of the committee and comply with the order of the passed by the learned single judge to conduct 4D and Durast work in italics as expeditiously as possible, but within the period of 9 months from that date. Full stop. The complainant did not appear on 17/1/2020 in the office of accused on 17/1/2024, but appeared on 19 January 2024 and submitted the necessary documents. A letter acknowledging the same is annexed with the present complaint. Full stop. Notwithstanding the same, took no steps or no further steps in that regard. Full stop. On 2/6/2025, in this view, the complainant was once again constrained to file a contempt petition. This contempt petition was once again, in this view, the complainant, on 2/6/2025, the complainant filed the present complaint, Notice in this present complaint was issued on 10/7/2025. Full stop. Even thereafter, no immediate action was taken by the accused. A compliance affidavit has been, a memo has been filed today, has been handed over today, enclosing therewith an endorsement dated 11/21, or enclosing therewith a letter dated 21/12/2025 addressed by the accused to the learned government advocate.
Has obtained the report from the RI Mellots on 8/10/2025. Subsequently, it has been placed before the committee members.
What is the reference 6 here?
My lords, your lordship, kindly see reference number 4, which is
reference 6. What is the reference 6 here?
Reference 4, my lords.
Look at page 5 of yours. As per Honorable Court's order, or judicial contempt case has been filed as per reference 3
Please, my
for
lords.
not taking action.
Please, my lords. That is
Accordingly, as per the Honorable Court's order and the petitioner's request, the original sanction file was reviewed for 4D and Durast. And since original sanction records related to Khatedar were not available in the file, a notice was issued to the petitioner as per reference 6. What is the reference 6?
The reference 6 is not forthcoming in the letter, my lords, but however, notice was issued, my lords. Thereafter, my lords, on 8/10/2025, a report has been called for from the RI, my lords, and he has given a report. Thereafter, it has been placed before the committee.
Don't take this lightly. Where is reference 6, where a notice has been issued?
There is some type of error in this, my lords. As in the letter, there is no reference 6, my lords.
Plain.
That will ascertain, my lords.
Plain reading of the letter also indicates, the said letter states that after receipt of the order of this court, after the contempt petition is filed, the file had been reviewed. And it was found that, reviewed for 4D and Durasti, and it was found that the original sanction records relating to the Khatedar were not available in the file. Accordingly, a notice was issued to the petitioner as per reference 6. It is noteworthy that the said letter has no reference 6. Full stop. It is alleged that since the petitioner complainant did not submit the documents within the stipulated time, and as the original document, the cultivation sheet was not available in the original sanction file, an order was issued on 1/3/2024 to present the matter before Missing Records Committee for action regarding 4D and Durast. Full stop. It is also stated that in view of the present contempt petition, the file has been pushed electronically to the Deputy Commissioners, Bengaluru South, and has been presented to the Missing Records Committee. And the committee has decided to verify the sanction conditions, or verify whether the sanction conditions have been violated, and to further present the matter before the next committee along with the Google map for the said land. Full stop. The said letter has no reference to the complainant's letter dated 19 January 2024, which is annexed with the present complaint. It refers to the letter of the accused refers to a letter dated 1/3/2024. Don't change the reference point. We may also note that this court had fixed a generous timeline of 9 months for the accused to complete the work. Question. More than 2 years have since elapsed. In view of the above, we prima facie view that the orders passed by this court have been willfully disregarded. The accused be present in court for framing of charges on the next date of hearing. Put this in April sometime.
Also file
Grateful, my lord.
Before next date of hearing, my lords, I'll also file the status report and
whether you file it or not, we now need to do something because we can't be having two contempts in this court spanning over 2 years.
Please,
you're increasing our workload, you're increasing your workload.
My
So might as well go somewhere else and do it or not be in this job. I think our message should go down very clearly now. Come there irrespective of it, we'll see what what thing to proceed.
Great, my lord.
7th April. Number 17.
Not in this case. The accused is supposed to submit the objection. The deliberately she is delaying or intentionally not coming forward. Maybe directed for producing before this coming.
Has service been done? Has service been done?
Yes. Yes, madam. Sorry, sir.
Let's see the order, the disobedience of which is
Which is the 4/9/2025, she received that and we submitted.
4/9?
4/9/2025, in the month of September. She received the copy.
No, which is the order which is?
Order dated 22/11/2022, page number 27.
22/11.
26 page number. And that order is also modified, my lord, the page number 28. And instead of at the home of the accused, and it has changed to the mall. May I read, my lord? The petitioner can meet his children on every date of case, so and so, between 3 p.m. to 6 p.m. and petitioner is permitted to take the children in nearby the mall. In between that period, they safely return to the custody of the respondent without creating any scene and without disturbing the peace of mind.
She's filed a case in Hyderabad.
Hello?
She's filed a case in Hyderabad.
Yes, I filed in Hyderabad.
What are the orders passed there?
The same order is there. It's like a kid can be visited in the Hyderabad court. Even there she don't come. Only once she visited there and the kids started, ignoring and kids started crying. Then the honorable judge met there and the kids clearly told that kid will meet anybody other than the father. The moment the kids start seeing the father, start crying. So that's the situation. And then we got the order from the same court for the psychological assessment of the kids. Even that we executed and it's under process.
So if they're crying and having a look at you, then why do you want them?
Hello?
If they're crying when they look at you, then why do you want to?
Hello, then the judge inquired that, and the elder kid has told that mother has shown the picture of the father and told he's a evil, he's a devil, and if he comes, he'll poison you, like that kind of word. We have a docket, it clearly shows that, my lord. I don't have a memo.
What is the age of the children?
10. So the dated 10.
What is the age of the children?
Children is right now, the girl is 10 years and the boy is 7.5 years. And when we got the order, it was a 5 years and 3 years.
Issue bailable warrants in the sum of rupees 10,000. List.
6th April.
Much.
December 18.
My lord, I'm for the accuser number 1, my lord. My lord. Sir. My lord, accuser number 1 has met with accident and now he is no more, my lord. Who? Accuser number 1, Mantesh Bilagi.
You have to get the second, another person.
No.
You'll have to substitute another one.
My lord.
You'll have to substitute.
Yes, my lord.
That's right. You have to substitute somebody in his place.
I'll do it.
The accused, number one, is accused is fired. The complainant shall take steps to substitute the complaint. Accused.
Ninth of April. The 19 disposed. Still number 20.
We'll take it afterwards.
Over. Number 21. 9th of April. Huh?
For the respondent in this case, my lord, I appear for the appeal to start. The commercial appeal is filed challenging the order of the Commercial Court in the interlocutory application filed along with the suit, the trademark infringement and passing of suit, wherein the Commercial Court had allowed restrained the appellant herein from using the mark Celtic for the product salt, which falls under class 30 of the nice classification, my lord. Celtic is derived from, so defendant's products, appellant here's products were available. Appellant here's products were available in the market named Namo Organic Celtic Salt, which was available for sale primarily in Amazon, Flipkart, and also in the appellant's website called namoorganics.com. The respondent herein was selling a product name under their registered trademark Sambike Foods for Sambike Celtic Salt, where they have claimed a user date from 2023. Celtic is a generic term. Despite being aware of that and they being themselves in the market, they approached the current Commercial Court and filed an interlocutory application seeking for an interim injunction. The learned, we had entered in the appearance force getting the summons. We had said that Celtic salt is a generic term. The term is arrived from the Celtic Sea, which is in the northwestern part of France. The salt which is derived from the Celtic Sea is known as Celtic salt. It's identified for that kind of products, my lord. Hence, we told it's barred under Section 9 of Trademark Registration. Trademark registration cannot be granted. In this matter, they claim to have filed applications. Their applications were not allowed, were objected or in the category of formalities check pass at the time of the suit. Right now, what I understand from the state is the three applications what they filed for Celtic, Celgris, etc. under class 32 have been objected and one has been abandoned. So accordingly, once when I got the interim order against me, I approached this honorable court. This honorable was pleased to grant a stay of the order. Hence, my lord, my contention is first primarily, if you see, the word Celtic itself is a distinctive and descriptive word. The Celtic is used to describe
your oppositions are pending.
The trademark registry is I objected there is a registration of the
oppositions are pending before the registry.
Yes, my
lord. We filed an application for registration of trademark.
So that is pending.
It's pending, my lord.
So let that be decided first. You can't injunct them.
It's a matter of trial, my lord. So in the entire country, my lord, I'm the first user of the Celtic.
Lordship, Celtic has been there. It's been used for 100 years. I have in my commercial appeal, I have put a series of other products where Celtic salt has been used. And also, my lord, just to bring your attention of your lordship, what I understand
on record, my lord.
Understood
number
from the
83.
trademark registry is their mark Celtic salt cell grist word mark under class 30 is objective. Celtic salt self-fin is also objective. For the registration for the application for the mark Celtic under class 30, they are abandoned. They are abandoning the mark itself proves that they are well aware that the lordship may permit us to bring this on record. They abandon the mark itself evidences that they are well aware this is a generic term and they cannot seek for trademark registration. If I was using their mark Sambige, I can understand I can be claimed as infringement. I'm not using the mark Sambige. They also admit that I'm not using the mark Sambige. In fact, my products are available in the market as Namo Organics. And also, if your lordship will well know, when you list the product in Amazon, Flipkart and all, there will be a category under which we can list your product. So Celtic is one category. So if I'm not able to use the mark Celtic or click on that category, then my product won't be sold.
Only on 3 submissions, my lord, with regard to that. But my lord, the Celtic, the term in India, my lord, we are the first user of the Celtic name. I mean, we also filed an application for registration of the trademark license. Then, my lord, the Celtic basically means C, which is not a generic term at all, which is a patently wrong, my lord. The submissions made by the applicant is totally wrong. Where, my lord, the learned trial judge has passed an order in favor of me, where the Celtic and Sampige are the not general term, which the plaintiff had filed an application for registration of trademark, which is still pending, my lord. So the matter has to be yet to be decided at the trial, my lord. So, my lord, the interim order is operating against me.
If there was a registered trademark, I understand they can ask sake of infringement. They don't have a registered trademark. How does the question of infringement arise first?
There are not been faced any records, my lord. With regard to Celtic is not a general term.
Lordship, may kindly see page number 25 of my appeal paper book, my lord. To be like someone claiming registration for Himalayan salt or apple cider vinegar tomorrow, my lord.
So we'll have to hear this. Put it for final hearing. What has happened before the commercial court?
Yes, my lord.
What happened in the commercial court?
Commercial court?
Trial has commenced?
No,
not yet, my lord. It has to be
No, not yet, my lord. After the IA has been disposed of, since there was order, the matter is not. To be honest.
Wait for final hearing.
15th of June.
Tomorrow may continue.
There are more orders.
Number 22.
Suit for recovery of money was dismissed. Last date of hearing, the matter was heard. I filed 2 applications seeking production of additional evidence, my lords. I filed another application which was directed to be filed in the registry. Short question, my lords, is a question of hand loan which I've advanced to the defendant from 2018-21. In the name of the defendant and his business enterprise. 2 issues were framed by the trial court, my lords.
Give them one more chance. Let them come. We'll give them one more opportunity. Nobody is present here.
No, my lords, they have been served and unpresent last 2 days. No advocate is on record.
Let's see the order passed by the commercial court. See, the question is, you have given your payments to Modi, is to the firm.
Initial payments were made to the defendant himself, thereafter to the firm of the defendant. His contention in the written statement is that he's taken over the business of Modi Sons post 2021. That is his case. He does not deny that he is nowhere related to Modi Sons. Lords, what I have produced now a document, the GST registration certificate, which is my appeal memo, which clearly goes to show that the defendant's name is registered in the GST so far as Modi Sons is concerned since 2017 itself, to show that he was in fact the proprietor of Modi Sons. My lord, it's at page 41, my lords, of my appeal memo, document number 1.
All right, we'll remand it back. We'll set aside and remand it.
And the question of question of limitation also is there, which has been answered in the negative against me.
Where is your limitation issue?
My lords, may kindly see the reasons. Page 87, my lords. Issue number 3 and 4 relating to suit whether it's barred by limitation. Page number 87 of the paper book.
Page number?
Page number 87 of the paper book, my lords. 10th line, my lords. Further, as rightly pointed out by the defendant, relying the contents of documents relied by the plaintiff himself, the transaction dated 15/1/2021, 16/1/2021, and 25/1/2021 are pertaining to the year 2021, and present suit is filed on 31/7/2024 after lapse of 3 years. Therefore, suit is hopelessly barred by law of limitation. Argument seems to be reasonable.
This you're claiming the benefit of that?
Yes, yes.
So moto.
Yes.
All right.
That's okay.
You have the copy of that order?
Yes, sir.
So motor order 3. We'll give.
The second judgment, my lords, page number 6. Second portion,
Yes.
page number 8, para 5 on this. That's the direction that is passed. The order dated 23/3/2020 is restored, and in continuation of the subsequent orders dated so and so and so, it is directed that the period from 15/3/2020 till 28/2/2022 shall stand excluded for the purpose of limitation as may be prescribed under any general or special laws in respect of all judicial qualities. Literally, my lord, the financial transaction in the year 2021, when the Supreme Court order was in operation, my lord.
No, which one are you referring to now?
My lord?
Limitation would have expired during this period. This limitation will expire in this period. This is what it is. There's one day. No, much more.
Urgent. One more IA was filed for production of documents. Twice.
We'll allow these applications.
Number 24.
I pray need to appear for the appellant's counsel.
Yes.
And is a case where a decree was obtained and in commercial OS 422 of
May be
24.
permitted to file counter to the application for condemnation of delay, my lord.
Yes.
Counter to the application for condemnation of delay.
Yes.
Copies.
Yes.
There was a previous order passed in a miscellaneous petition, Mirad, in the same court, in the commercial court. That was by which the petition was rejected. There, on that, Mirad, we had preferred a commercial appeal, confining ourselves to the petition under Order 9, Rule 13, as mentioned by my lord in para number 2. They have confined the present appeal, challenging the impugned order whereby the appellant's application for setting aside judgment decree was rejected under Order 13, Order 9, Rule 13. Now, that apart, my lord, I am pointing out to this honorable court that, my lord, it's a matter of record that, my lord, the defendant's case has not been put forward before the trial court at all. Purely on technical grounds, they have been kept away. Admittedly, only from the stage when the property is attached. Now it is brought for sale. I believe it is scheduled to be sold in public auction on the 5th and court sale is on 7th. The short manner in which the case was filed, summons was not served upon the defendants. One signature is found from the certified copies.
That is over, that we have already decided.
All I am requesting is Sangram Singh's case. I am relying upon that judgment.
To show what is on the record, what is it that the...
All through I have been kept in the dark. I have no option. The civil procedure code, my lord, it is an opportunity to contest, my lord. They cannot trip me away from the court and say that we have obtained decree. Therefore, the whole thing is a fraud according to the defendants. The challenge is so far as the transaction itself is concerned on merits. We have never had any transaction regarding 116, 120 kgs of silver at all. The proof is pertaining to a separate loan for 40 lakhs for which we have no grouse. We admit that fact.
Let's see what the judgment.
Judgment believes, without any documentary evidence, the court believes the fact that there is a transaction, and my lord, kindly see the judgment. Paper book and judgment. 98 in the paper books. Suit for recovery of 1 crore 12 lakhs 50,000. Case of the plaintiff in brief is so and so. And kindly come to the documents. I'll read the whole thing. It's a short judgment. The plaintiffs were running jewelry shop in name of Srinath Jewelry Mart at Raja Market Avenue Road. On account of health issues, the plaintiffs closed the said business, having stock of silver worth 120 kgs. Defendants, also being engaged in jewelry business in the month of March 2020, approached the plaintiffs requesting them to give 120 kgs of silver, which they intend to use the same in their business, and agreed to pay a sum of 66,000 per month as interest. Allah also agreed to return 120 kgs of silver after 1 year. Believing the words of the defendants, the plaintiffs gave 120 kgs of silver to the defendants on 3/3/2020. The defendants gave 7 checks worth 56 lakhs and also executed a letter to the effect of 3/3/2020, mentioning the details of the checks and amount in each check. In addition to the said transaction, the defendants also availed hand loan of 40 lakhs from the plaintiff by mortgaging title deeds of their property bearing number 2, municipal number so and so, situated in ground floor at Chaudeshwari Temple Street, Chikpete, Bengaluru, and registered the same in the office of the sub-registrar, Gandhinagar. The plaintiffs further submitted that the defendants have paid interest at 66,000 per month till 29/5/2021. Thereafter, they have stopped paying interest and also did not return 120 kgs of silver. It is submitted that in spite of repeated demands, the defendant kept postponing the return of 120 kgs of silver, also failed to pay the cost of silver. During the first week of August 2023, the defendants requested the plaintiffs to present the checks gave by them towards payment of cost of 120 kgs of silver. Accordingly, the plaintiffs presented the following checks for encashment. All the checks, my lord, is 9 lakhs with 2/8/2023 is the date. simultaneously filled up with the same date throughout, and all checks were presented as per page 102 for encashment at State Bank of India, Puttanalli branch on 2/8/23 and the Gandhinagar branch and on 5/8/23. All checks were dishonored with Sharaf, payment stopped by drawer, which was intimated as per memo. Thereafter, plaintiffs informed the defendants about dishonor of checks, but defendants have failed to make payment. Finally, 22/8/2023, plaintiff issued legal notice calling upon so and so. Thereafter, plaintiffs filed an application for pre-institution mediation, commercial court, district legal services. Notice sent through under mediation was served on the defendants, but the defendants failed to appear and pre-mediation institution proceedings came to be closed. Concerned authority has issued non-starter report, etc. Kindly come to the next page, reasons, my lord. Plaintiff 1 in support of plaintiff governments filed his affidavit by evidence reiterating made in the plaint. He has also got marked 15 documents, exhibits P1 to P15. P1 is the letter issued by the plaintiff executed by the defendants in favor of plaintiff with respect to taking off 120 kg of silver.
Let's see the evidence on record. What is the evidence on record on lending 1 lakh 120
Please, Manan.
kgs of silver?
Exhibit P1 is what they say. Exhibit P1. P1 and P2. P1. My lord, exhibit P1 is a letter by which the plaintiff claims that it is returned to him. You are aware that during the course of business, you have supplied 120 grams of silver on several occasions. With an understanding, we have agreed to return silver metal within 1 year and also paid 66,000 towards interest per month in view of the supply made by you. We have also arrived at an understanding that the interest and profit silver will be reduced proportionately as and when delivered the silver and interest on completion of the return of said silver. You are required to discharge the DTD subject to payment of 40 lakhs. So that's what it's mentioned. Nowhere it is mentioned as far as the claim and receipt of those one-time payment is concerned. That is Exhibit P1 marked in OS, Commercial OS 422 of 24. My full submission firstly is that I had no occasion to file written statement. This is a background of the case is important, my lord. I have to state it orally because I have not been able to put it in writing before the trial court. I have been prevented from appearing and contesting the matter. There is a suit for partition and separate possession amongst my brothers and myself. We are all litigating towards the property which my father has left. Unfortunately, the plaintiff Linga Shetty is related to my elder brother. He has been set up by my elder brother to file this false suit and disposes me from the only business that I am doing in the shop. I have borrowed 40 lakhs from him is a fact. I have to repay it is also a fact. If I was given opportunity to contest the matter on merits or settle the matter, I would have settled. The first instance, PIM also, I did not receive any summons. My son's signature has been forged. I found from the certified copy today also I verified the signature of my son has been forged in the registered post notice sent from the commercial court. On that basis, the commercial court has made an order noting on the order sheet that the registered post is served. But my lord, on the same day, the noting says that copies are not issued to the assessed to different through court, not issued for want of copies. My lord, kindly see the notings, my lord, 25/4/2024 noting, my lord. It is in the certified copy which I have got. I request this honorable court to kindly have a look at the notings. I can find the copies itself with a memo, my lord.
No, this is not a ground that you took in the earlier case that your signatures are for.
Unfortunately, he was not being represented properly is my humble submission.
No. You were proceeded.
I am taking these grounds, my lord. I can, at the law, even, I have no other way, my lord. I have no other way.
You have no other way.
That is what I am saying.
You had a suit comes to be filed.
My lord,
You don't appear.
I didn't receive summons.
Summons were issued. Then you filed an ex parte, you filed an application saying that after some time to say that you should be, your ex parte decree should go. That is rejected. There you don't say your signatures are forged.
That was the problem, my lord. It was not represented properly.
When you file an appeal.
This is a mistake of the counsel who represented. He did not take proper steps. Sir, let me complete.
Even in the grounds of appeal also such a ground is not taken.
Here it is taken.
Here they have not, the ground is,
here
there is no ground that
Kindly,
there is a
kind
forgery.
challenge
etc.
of the decree and order sheet.
There is no ground that there is a forgery of his signatures have been made as with regard to service of summons. No, that is
At
not the
any
ground.
stage, fraud can be pointed out, my lord. I have verified, my lord. That is a fact, my lord. Sangram Singh's case is on ripe. May I read that judgment?
You can have you can look at it again and now come back, have a fresh thought, so you'll find a fraud.
My lord, Sangram Singh's case would apply, my lord, is my humble submission.
That we will deal with.
All I am requesting is, my lord, all I am requesting is an opportunity, my lord, to contest the suit on its merits.
That's not the scope. You tell us what is your.
My request is 40 lakhs, my lord, is what I am due. I would pay it in installments and close this matter. I am not due that 120 kgs of silver. Why will anybody, without law, he would have lodged a police complaint in the natural course of business or circumstance if I had defaulted. He has not done so, my lord.
What about this P1? This is also forged.
Forged?
This 23 page.
Yes, my lord. Kindly see the signatures.
It is his letter, my lord.
That's what they say. That's what they say. The court has believed because I am ex parte. No contest. Very cleverly they avoid the postman and see that the signatures are forged. It is possible that has been done.
No, not postman. We are talking about P1.
No, including that document, my lord.
That is also forged.
Yes, my lord. This is clearly concocted. They might have obtained blank signatures while giving that 40 lakhs and used it to subsequently now added. It is a fact that they have added that.
Are the signatures forged or are they blank?
My lord, I would say that the signatures.
No, you can't say anything. You have to say it in your what have you said in your.
I have to put it in writing, my lord, and say.
So what? Where have you said this?
No, that is not said in the.
My lord, I am placing additional grounds, my lord, if permitted now. They have been very badly let down is my humble submission, my lord. They have been kept in the dark and the whole family is on the streets. They don't have proper facilities to live. Now, ex parte sale of property is slated on the 5th, my lord. Spot sale and court sale is on the 7th.
Pre-mediation notice is also served. Notice, legal notice is also served. Then there are court notices also served.
This is admitted. Plaintiff only says it is only the party. That is it.
माझे कडे का द्या Cross examination PC ಯಾರು ಹೇಳಿದ್ರು ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಷನ್
Somebody else.
ಇಲ್ಲಿ ಯಾವ ಪೋರ್ಷನ್ ಈ ಕೊಟ್ರೆ ಎಲ್ಲ ಗ್ರೋತ್ ಯಾಕೆ ಮಾಡ್ತಿದ್ರು ಅರ್ಥ ಮಾಡ್ಕೊತ ಮಾಡ್ತಾರೆ.
Lord, his signatures are found. Checks are there. It is at page number 27. The same signature is found. Page number 29. Another signature, another check, same signature is found.
No, but signature forged is what you are saying. Nothing stated anywhere that the signatures are forged.
Yes. In the cross examination on the CC case, Manad, we have suggested, because that is the only place we are contesting, Manad. We have been suggesting and we have brought out answers also. We can file the Kannada version with the English version also. The cross examination of the complainant, who is the plaintiff. He has filed criminal cases under section 138 of the NI Act. There he has admitted that the signatures and the handwriting on the checks are all filled up by him, and his signature is also different.
No, signature is odd. Your checkbook is yours, no?
Checkbook is mine, but not it is for. He has obtained that as some security towards that 40 lakhs. He uses it for this silver ballot. That is the only proof. There is a.
Uses it as if he is taken into security.
There is no direct relationship as far as that business is concerned. It is created, is my humble submission. As far as 40 lakhs, we are not disputing.
Apart from P1, what else is there?
Apart from P1, Millard, the notice has been issued. The notice he has received it, and then thereafter, 12A mediation, pre-mediation notice has been served.
No. Prove that you have given 120 kgs of silver.
It is his letter, Millard. Exhibit P1 is his letter.
That's right.
He himself says that I have given 120.
Apart from that, there is anything
No,
else?
I don't have any other letter.
No document.
No other document, Millard. This is the exhibit P1 is the, it is their own letter.
There is no GST, there is no transfer, there is no making design, nothing. No foolproof evidence. The learned judge simply accepts whatever is given by the plaintiff. Within a couple of days, decree is passed. All I am requesting is an opportunity to place all material and conduct. Even a week's time would be sufficient for me.
Let's see your limitation, application for limitation. You see your application for limitation for condonation of delay. You have said you admitted the receipt of summons.
But I'm under the impression that these signatures were obtained and there is absolutely no proof when I compare it.
One question would be whether you received it or not, your signatures are forged or not, that's a separate issue.
My respect.
Here you say it served on you.
It's a category. It's not a categorical statement.
It's a categorical affirmed by an affidavit that it is served on you.
Please, ma'am.
The issuance of RAPD was served upon us. After you've sworn an affidavit in this court to say that you've received summons, you now want to argue your summons are not received and it's
We
forged.
compared the signatures, ma'am.
No, not a question of comparison. You said I've not got it by email, I've got it by RAPD.
RAPD.
That's right. So you got it. What are the dates?
Dates, my lord. The 3/3/2020.
Suit is the decree, the judgment decree is?
Judgment decree is dated 35/2024.
Madam, the Lordship, para 3 is, madam, is what your Lordship referred in the affidavit. It's wrong drafting by way of, because lack of English knowledge and drafting. What else? They have not admitted, madam. That's the fact.
All right. Leave it at that.
May I read, madam?
No, please leave it at that.
Because I find there is no, but the issuance of RPD was served upon us, place it our presence ex parte. That's what it's, whatever is mentioned in the judgment, it is mentioned. ಎಲ್ಲಿ ಇಲ್ಲ ಅಂತ.
35/2024 is the date of the judgment and decree. Execution was filed on 13/9/2024. 35/2024. 35/2024.
That's the judgment.
13/9/2024 execution is filed after 4 months.
All right.
30/11/2024 they filed the application under Order 9 Rule 13. The application was heard and it was dismissed by the trial court on 5/4/2025. Thereafter, they filed the miscellaneous appeal before commercial miscellaneous appeal number 88 of 2024 before this honorable court on 30th June 2024.
No, can't be. It will be 30th June 2025.
25, Millard, sorry. 11/8/2025, this honorable court has been pleased to dismiss the appeal. It is thereafter the present.
Challenging
the High Court like it. The present appeal is filed on 30th August 2025.
Then this is over on 11th August 2025.
11th August.
Their appeal is dismissed.
Yes. 11th August 2025, the appeal is commercial appeal AP 391 of 2025 has been dismissed.
Then they filed this on which date?
This was filed on 30th August 2025.
Did you furnish your affidavit by evidence?
Yes, my lord.
Where is that?
Evidence. My lord, it is at page number 14. In the paper book itself, they have produced it. Pre-mediation notice ಯಾವತ್ತು ಸರ್ವಾಗಿದ್ದ? Pre-mediation notice. Prior to the filing of the suit, pre-mediation notice has been sent to him. It was served. That report you will also get it page number 97. Pre-mediation report.
Any payment, payment of interest?
Payment of interest, they have paid it for 1 year.
How?
They have directly remitted to my accounts.
Where is that?
That document, they are not disputing it. I have not produced the document for that. There is no dispute.
Before the commercial court, did you produce the evidence that you have received interest of 66,000?
I have not. I have stated that they have given me the interest at the rate of 66,000 for a period of 1 year. That is in the print also. I have stated so.
Is it reflected in your bank statement here?
I don't have the bank statement immediately.
Not in the paper book.
Not in the paper book. Para number 3 of the judgment of the trial court, it is mentioned the plaintiff further submitted that the defendants have paid interest of rupees 66,000 per month till 29/5/2021, and thereafter they have stopped paying the interest.
That is
and
your
also
affidavit.
did not return 120 kgs.
That is your affidavit.
That is my affidavit. That is my plain government also. Even in the pre-mediation petition also I have stated so. They have served with the notice. Your Lordship would get it. Page number 97 is the report, pre-mediation report, my Lord. It is dated 13/2/2024.
Which page is it? 27. 27 is it?
97, my Lord. I don't know. There are 2 pages, 2 numbers. 197 and 45.
97 and 97.
97. This is 97 one. No. Report says that as per rule 3.4 and 3.4, on perusal of track report, notice served on the opponents 1 to 3. Opponents are called out absent Hence, the petition is closed. Application was filed on 10/1/2024. Scheduled date was 12/2/2024. Next day, the case was closed. Pre-mediation case was closed.
Parties' names are different. Architect and this is different is Chandrasekhar.
And others, it's shown as and others.
How have you calculated 1 lakh? Your suit is for 1 lakh, 1
crore 20 lakhs, being the value of 120 kgs of silver, my lord, as on the date of filing of the suit.
What is the evidence for that?
What is the evidence that you
20 lakhs below.
My lord, 120 kgs of silver, that is page number 19, 1 crore 12 lakh 50,000 is what has been claimed. Out of that, 90 lakh 72,000 is the value of the silver as on the date of filing of the suit. Then the interest what he has paid from 1/6/2021 till 21 lakhs. Interest paid is also acknowledged here.
You got 18% from the date of the suit.
From the date of the suit, my lord.
Do you have your 138 complaint with you?
138 copies of the proceeding. I have produced the complaint copies only. I have produced. Your lordship would get it at page number 20. It starts at page number 29. Lord. Order sheet complaint. Your lordship would get it page number 49. ಮಾಡಿರೋದು 49.
Now it's actually showing up in limitation. Where is 138 reached now?
It is no argument is over, my lord. It is posted for judgment. Orders on 5th. In fact, in the said 138 proceedings, The very same exhibit P1 has been confronted to my witness by the respondent himself.
Yes.
Exhibit P1 here, what has been produced, he himself has confronted to my witness and got it marked as exhibit D2, D3.
All right. You don't even have any ground for delay here also. You are now, in fact, and filing of the first appeal as a statutory right cannot be curbed on the ground of delay.
Please. One humble request is
You find no grounds to
keeping open the fact that the contest on merits, because let me at least protect my properties as far as properties are concerned, unconcerned with the transaction. Only the mortgage is in force. He still had time to recover the money from the mortgage. Yet that also is decreed without following proper procedures for foreclosure. There is no notice of foreclosure, nothing.
Foreclosure is not before us. We only have money decree.
I have not sought for foreclosure. It was not a suit for.
Not a suit for mortgage.
No, it is not based on mortgage.
Then, Malad,
for the above, just take down. We find no grounds. We are unable to, in absent any explanation, credible explanation for condoning the delay, we are unable to succeed to the said request. The application is accordingly dismissed. The appeal is dismissed as well. Consequently, the appeal is dismissed as well. The rest will dictate it out. The rest of the thing will dictate it.
25, 26 are urgent. Number 27.
Okay.
The appellate appear for the authorized order. Dismissing the writ petition, that confirming the order of the district judge. Where that it is in a section 16 pre-petition file. That after 10 years, that it is where that line was drawn in the year 1996. That compensation that according to paid, that the trial court not observing that no material which has been produced. And even that it is in a first time that the 2006, the notice was issued after 10 years, claiming compensation.
What about your delay?
That my defense blood that we have paid compensation.
No, your delay.
The delay my our part, not that we are approval, all those things, not that we are securing the information change, not that okay, the long blood that in the 96, not that which has compensation is paid. That securing information where that it not that it is concerned.
Lord, I have also filed my objections to the application filed by filed under Section 5 of the Limitation Act, my Lord. There is delay of 273 days in filing the present appeal, my Lord.
Well, let's see your main ground. Main ground is limitation.
Yes.
Lord, electric lines were laid in my land way back in the year 1996, my Lord. I was not paid any compensation. In the year 2006, my Lord, I filed application under Section 16 to the district court seeking for compensation for the mango trees that were cut down in my farmland for laying of these lines, my Lord. Trial was conducted, and their contention before the learned district judge was that, my Lord, compensation was paid in the year 1996, my Lord. No compensation was paid, and in spite of giving several opportunities, both before the district court as well as before the learned single judge, my Lord, not even a scrap of paper they have been able to produce before the court to demonstrate that 2 lakh was paid as compensation in the year 1996. Hence, my application that was filed in the year 2006, my Lord, was considered and compensation was awarded, and which is already paid, and I have also received that, my Lord.
Compensation paid.
Lord?
When was it paid?
In the year, only upon me making application before the district court, my Lord, 3 lakh compensation was fixed. 3 lakh and odd compensation was fixed. And I have also, and my instruction is that, my Lord, my client has also received that compensation, my Lord. Subsequently, challenging that order, my Lord, they have come up before this honorable court. And single bench has confirmed the order passed by the learned district court, my Lord. Challenging that order, my Lord, they are before this honorable court, saying that it is barred by limitation, my Lord.
No. The learned single judge holds that there is no limitation because compensation was not paid.
Was not paid, my Lord.
So when was it paid?
Only upon the order passed by the district judge, my Lord, after the order passed by the learned district judge, my Lord. In miscellaneous petition number 114 of 2006, my Lord.
So that was challenged before the learned single judge.
That line was done 1996. That first time, that in the year 2006, that notice was got.
So when did you pay the compensation?
The compensation during that time has been paid 2 lakhs. That.
Where is that?
That material on account of after lapse, that we are not, that place is concerned.
When did you deposit the compensation? If you not
compensation paid, directly paid to the party, that we are not deposited before.
When?
That is in the 96 itself.
No, that's not what he's saying.
That
That's
he
not
is
what
now
this-
not that taking advantage that we know material we have placed, that is the denying so far as that is concerned.
Where have you said that you paid in 96?
That I have stated in that appeal memo.
When?
96 it has been paid 2,02,009 rupees to her damages. That is the why that delay in securing information that how much payment made because of the agent was made that it is during such time.
Learned single judge holds that you have not paid.
That the lack of the material that it has been that where that not paid. Even otherwise, that I made my submission.
Don't say, well, let's have a fact straight. The learned single judge has said that you have not paid and therefore your limitation will not run. You cannot fault the learned district judge for taking up the compensation claim. Couldn't be barred by limitation because you've not paid. You say you've paid.
Yes, yes.
We are asking you which is the date. Obviously, that flows from the order of this learned single judge.
That single
if you think the learned single judge is incorrect, then you should point out.
That is not that I sought for the bank statement to the transferring fees, not that cash will not pay, a bank transfer.
Whatever.
Old bank, not that securing that, not that bank statement. That is not that it is in a delayed so far. That is why that twice I took.
At least you can say you can say which.
That definitely I'll place it on that kindly one opportunity.
You can't. There 273 days. You not challenge that at all.
Not that if the compensation would pay, not paid, not that 96, not that till 2006, not that it is an that after the 10 years, not that come with an saying that compensation.
You not paid 10 years, no? Had you paid, the matter would have got over.
In spite of giving opportunity before the trial court, before the learned single judge, the trial court has awarded compensation only at the rate of 400 rupees per mango tree, my lord, which is very feasible.
Mistake. The appellant has filed the present appellant bracket here after KTT CL. The appellants have filed the present appeal impugning an order dated 6 June 2024 passed by the learned single judge in writ petition number 10651 of 2017 bracket J by AEB. The appellants had preferred the said petition, assailing an order dated 31/2016 passed by the learned District and Sessions Judge Tumkuru in miscellaneous petition number 114 of 2006. Good stuff. The said petition was filed by the respondent claiming was filed by the respondent claiming compensation for an amount of rupees 8,20,000 on account of the damage suffered as damages suffered for removal of mango trees, 80 mango trees. By the appellants bracket KPTCL for laying the lines on the lands belonging to the respondent. Full stop. The appellants had contested the said claim. They claimed that the respondent's claim was based on the assertion that each mango tree was yielding rupees 500. This was contested by the appellants. However, during the course of the proceedings, the appellants also raised the issue of limitation. Full stop. They claim that the electric lines were drawn in the year 1996. However, the respondent had filed the petition under section
16, Lord.
106. So, 19 of the Indian Electricity Act 1910, read with section 10 and 16 of the Telegraph Act 1985 in the year 1996, in the year 2006. Good stuff. Although no such ground was raised in the statement of objections filed in the written statement of objections filed by the appellant, the said contention was advanced at the time of hearing. Full stop. Next paragraph. The learned district judge did not accept how the learned before that it was the respondent's contention. The respondent contested the challenge on the ground of limitation. This is the respondent's case that he had never received a notice intimating the compensation fixed for the loss caused. After and he continued to await the same. However, in the year 2006, the owners of neighboring land, compensation was disbursed to the owners of the neighboring land, and therefore he issued a legal notice to the appellants demanding the same. So, although the appellants received this notice, they did not respond to the same. Therefore, the respondent was constrained. And therefore, the respondent had approached the learned, had filed the petition. Full stop. Next slide. The parties had led the evidence, and the learned district judge found that, district court found that the appellants had unable to refute the respondent's claim that he had not received any notice or compensation. Full stop. Although the appellants claimed that they had paid compensation and had paid the compensation to the respondent, there is no evidence to establish the same. We may note that even in these proceedings, no documents have been produced to establish that any payment, that the compensation had been paid. We may note that neither before the learned single judge nor in the present appeal, we may note that the appellants have not produced any evidence to show that the compensation had been paid either before the learned single judge or in the present appeal. Full stop. It is not disputed that 400 kV electrical lines had been raised over the land of the petitioner, over the land of the respondent, and he was entitled to compensation. Full stop. In view of the above, the learned judge had rejected the contention that the respondent's petition was barred by limitation. The appellants appealed the said decision before the filed a writ petition, being WP 10651, challenging the said decision. However, the learned single judge found that there was no evidence that the appellants paid compensation to the respondent, and therefore the limitation for seeking and issued a notice of compensation or paid compensation to the respondent, and therefore the period of limitation, and therefore its claim would not be barred by limitation. Full stop. The learned single judge also noted that in terms of under section 10 bracket D of the Telegraph Act, the appellants were obliged to pay compensation for the damage suffered. Full stop. Next paragraph. The appellants have, the learned counsel of the appellants submitted that the present, that the petition filed by the respondent was barred by limitation on the same grounds as were canvassed before the district judge as well as before the learned single judge. However, the appellants have not produced any document to evidence either payment of compensation, either issuance of notice of that the notice of compensation was received by the respondent, nor have they produced any documents in support of their claim that the compensation had been paid. Full stop. Was paid. Next paragraph. We may also note that the present appeal is filed after an inordinate delay of
273 days.
273 days. The application seeking condonation of delay does not set out any credible reasons for the said delay. It merely states this is sufficient explanation for that. Don't say credible reason, sufficient explanation for the said delay. Full stop. It merely states that the Writ petition was disposed of on 6/6/2024. And the advocate had applied for a certified copy of the same. Applied for the certified copy of the same and forwarded to the corporate office on 25/11/2024. Full stop. An approval was obtained for filing the writ appeal on 5/12/2024. Thereafter, the advocate sought for certain information with regard to the compensation paid to the respondent at the time of drawing of the electricity lines over his land. And after securing the said record and the information that a sum of rupees 2,02,009 had been paid, the present appeal was prepared. However, as stated above, the affidavit is, the application is bereft of any details as to any specific dates, is bereft of the relevant details as to the specific dates, as to when was the certified copy of the order applied for. So when was the when did the advocate seek further information and when was it supplied? Full stop. The explanation provided appears to be, it doesn't appear to be credible considering that the appellant has not provided any information, has also not provided any material in support of its contention that the compensation had been paid to the respondent at the time of drawing of the lines as contended. In view of the above, the present appeal is dismissed both on the ground of, in view of the above, I have no grounds to condone that, to allow the application for condonation of delay. In view of the above, the appeal is dismissed both on the ground of delay as well as on merits.
Grateful.
Says mentioned matters. List 1, serial number 40.
Copy of petition. In this much minutes,
I'm appearing to the in the granted matter.
Yes.
I'm appearing the granted matter, my lords. That is, Mr. Ravi
Kind of
Shankar
40 is the one.
40.1, my
Yes,
lords.
Who's appearing in 40?
40 I appear for 40 minutes. This the matter is disposed of minute. And this honorable court noticed minute that the part by refusing the interim order, the construction was completed, and therefore minute via media was suggested that every transaction that takes place minute in that area, 2% additional stamp duty to be paid. That's how the matter was going on. Particularly through an IA minute, the government sought permission to develop a particular area minute through the money that was that's realized. The matter ends so far as I am concerned.
Then Mr. Ravi Shankar's party, my lord, they had complained that it is their part of land that is now being used, my lord. That's how the application is filed in my case. I leave it to the court so far as I am concerned.
Who's pressing that application?
Earlier, my lord, I had filed the application in the 1996 matter, my lords. That is 40, my lords.
Yes.
Subsequently, I filed a separate petition, my lords. That is 40.1.
Yes.
On the ground, my lords, I was not party to the writ petition.
Yes.
An order came to be passed, my lords, without making me a party. And an order is passed, my lords, on 25/3/24, which I have impugned, my lords, in the subsequent petition. That is 13256, my lords. I have impugned the order, my lords. Earlier, I had filed the IA, my lords, in the earlier matter.
Yes.
At Annexure A, my lords, page 26 is the order passed by this Honorable Court.
Yes.
This order, my lords, wherein, my lords, my land is given for the purpose of building a public healthcare center without, my lords, giving me an opportunity of hearing. The Deputy Commissioner, my lords, after the order of the Honorable Court, transfers the land, my lords, from me to building a public health center, my lords, without giving me an opportunity of hearing, my lords. Therefore, my lords, I challenge this order before, my lords, the Karnataka Appellate Tribunal, my lords. The Appellate Tribunal, my lords, rejected my application on the ground that this Honorable Court, my lords, in the impugned order, had directed construction of the public healthcare center. Therefore, my lords, my appeal against the order of the Deputy Commissioner came to be rejected, my lords. Then I filed a writ petition, my lords, before the single judge. Your Lordship will see the order, my lords, at page number 146, my lords, is the order. I had challenged the order of the Deputy Commissioner, my lords, before the single judge. Lordship will see 152, 11 page, my lords. Para 7.
Yes.
Upon a careful and plain reading of the directives issued by the division bench in WP so-and-so, this court is the considered view that the interim order granted earlier in favor of the petitioner requires to be vacated. The division bench issued a categorical direction to the state to commence the proposed construction of a primary healthcare center in survey number 21, measuring 6 guntas. Furthermore, the division bench.
Yes.
Furthermore, the division bench 152 minutes. Furthermore, the division bench has emphasized the urgency of the project by explicitly stating that the construction needs to be accomplished on a war footing. In view of such clear directive, this court finds no justifiable reason to continue the interim order. That was my submission. The interim order passed by this honorable court on 25/3/24. This challenge, my lord, was passed without giving me an opportunity of hearing, my lords. I have been, my lords, told I cannot challenge the order, and my interim order got vacated, my lords, on the sole ground that this honorable court in the impugned order, my lords, has passed an order directing that the primary health care center, my lords, be built in my property.
Yes. You have not appealed that order.
Lords?
You have not filed an appeal against that order.
Immediately, my lords, I filed a writ petition, my lords.
You filed a separate writ petition.
Please.
Question is, how will you maintain a writ petition against an order of a learned single judge?
No, lords, I have, my lords, the lordship will see my petition, my lords, para number 19. I have not challenged the order of the single judge, my lords. I have challenged the order of this honorable court, my lords. I have sought for review of the order of this honorable court.
You are challenging the order of 25/3/2000.
Please, my lords. At page number 25, along with the petition, 26, my lords, along with the petition of this honorable court, my lords.
Yes.
My lord, I'll take notice, my lord, and I'll seek instructions. My lord, may I see respondent number 8?
Yes.
My lord, he is dead.
My lord, serial number, the respondent number 8 to 11, my lords, were the parties in the first matter, the 1996 matter. Therefore, my lords, I had to make them a party, my lords.
You can delete them, a person
please,
is
my lords.
expired. 8 has expired.
Please, my lords. In fact, my lords, your lordship will see, my lords, the earlier petition is disposed, my lords. My cause only is against the state government. The private parties are no more involved in the matter. My grouse, my lords, only against respondent number 2 to 7, my lords.
So why have you made them the
Because they are parties to the earlier petition, my lords. It's a review petition, my lords. I had to make all of them parties, my lords.
It's not a review petition. You filed a fresh writ petition.
Review, my lords. Your lordship will see the prayer, my lords, in my petition.
Then we'll examine your application for review in that. Why do we require a separate writ petition?
Because I was not a party. The Supreme Court, my lord, says if you're not party to a order, you can file a fresh petition, my lord. Hence, I had filed the petition. That's the only reason.
May I just clarify that position, Miller?
Yes.
Miller, in the order dated 13/4/1999, passed in 31/8/15 of 96, this honorable court has made the position clear, Miller. The writ petition is kept pending only for the purpose of monitoring of deposit of 2% of amount and to appoint an independent body as stated supra for the purpose of framing of scheme and utilization of the amount. In all other aspects, writ petition is deemed to have...
Your PIL is on use of funds.
Your lordship, sir. No. Writ petition was filed. PIL was filed for in respect of a property developed by Sinister Miller, Mr. Dharmendra. Then Miller interim order was not granted. By then, Miller, by the time the writ petition came up for final hearing, the building had come up, Miller. Then this honorable court felt, Miller, that instead of directing demolition of the buildings, this is what the court said. The subject matter of this petition was for the sale of agricultural land for the purpose of setting up residential apartments in the South City. By the time final order came to be passed, it was observed that structures had already been completed. That is 13/4/99 order may be seen, Minute.
Madam, you have to take instruction in it. The PIL was something else.
Something, yes, Madam, that's true. Your lordship is right. Therefore, so far as that writ petition is concerned, that is closed. But Miller, the property that was developed there, this honorable court is a novel method, Miller, they found out, Miller.
That's not, his property is not a subject matter of the writ petition. Your
No,
PIL.
Miller, no.
That's all that he's saying.
Then
this is nothing.
You can't build on somebody else's property.
Lord, I don't know what the stage is and what the current situation is.
No, you've come back and said, we've got a property, please allow us to use the funds to build that. Court said, all right, instead of getting something else, you build there. Now he's filed and saying it's my property. To that you said, the division bench just said, build there, so you build there.
Their case, my lords, before a single judge, their case, my lords,
What was the order before the
my lords?
What was the order? You had an interim order.
I had an interim order, my lords, to stay of the Deputy Commissioner's order, my lords.
No, what was the interim order in your case?
Before the single judge, my lords, there was a stay of the Deputy Commissioner's order, my lords.
Lord,
Not to assign the land for development, my lords. Now the problem is they've already built 3 floors of the project, my lords. I'm only requesting for status quo as on date.
Tell us what.
My lords, my only request is they built 3 structures. They're going to start a primary healthcare center. My lords, then it will be
If they build the structure, how does it?
Status quo as on today at least.
Give you
or a short date, my lords.
Yes, give you a short date,
please.
Both will have to be. Because if you have this will be the There's a notice in 40.1 and also in the application filed in 40. So
16th and 17th may be avoided, means.
6th of April.
Grateful.
Obliged.
Yes.
it's a notice to all other respondents other than respondent number 8 in 40.
Number 49.
It's a shorter date. I'm sorry.
Yes.
Sorry for pressing much shorter date. It's because they're building.
April we viewed.
Like this month, not
April is fine.
Please.
Number 49.
Appear for the complainant in the matter, my lord. My lord, this contempt case stems from an order dated 20th February 2025, where the respondents were directed to hand over possession to me in respect of a property in which there were two connected petitions before the learned single judge, and claim of encroachment was ruled in my favor. And if your lordships may turn to page number 18 of the main petition, my lord.
Yes.
Which matter? 49, I'm not there. No,
Okay. We'll list it tomorrow.
Tomorrow.
We'll wait for it.
I'm busy with my work.
Let's put both of them together. One more.
This goes still number 26.
Respondent, please.
Yes.
May I?
Half an hour. Do it for 15. We'll give you 15 minutes. We'll give you 15 minutes tomorrow. The other one is also tomorrow. The other we held back matter tomorrow. Outside matter. Yes.
Yes, will just pass along the same chat minutes which the learned senior had referred to.
Yes. Yes.
Notes there are three portions, my lords, of the subject road. Notes the first portion, my lords, is marked as number 1. My lords may have that sheet of paper for a moment.
Yes.
My lords, the first chainage, my lords, pertains to a flexible pavement, which forms, my lords, about 26%, my lords, of the project cost.
Yes.
My lords, the second portion, my lords, there is a U, my lords, marked on top, my lords, of the second portion.
Yes.
That, my lords, is the Sakleshpur bypass, my lords, about 6 kilometers where I've executed the work. That is an admitted position, my lords, of the facts. My lords, the fourth portion, which, my lords, is marked in X, is, my lords, the rigid pavement, my lords, which constitutes about 58%, my lords.
This is U show. U is a bypass.
My lords, that is the Sakleshpur bypass, my lords.
Right. That's a part of the contract.
Part of the contract, yes.
All right.
Then, my lords, portion number 4 is, my lords, where the rigid payment, that is the concrete payment, my lords, were to be executed,
Yes.
which forms, my lords, about 58% of the contract price.
58%.
Yes, my lords. Of the total 90 crores, my lords, was the 90.27 was the total contract amount. It had, my lords, the flexible pavement, rigid pavement, my lords, additional works, miscellaneous, that is, my lords, the road signages and the shoulders, everything, including, my lords, the maintenance. That, my lords, was the total contract. My lords, the argument, if my lords were to recollect what was argued, my lords, on behalf of the appellant, my lords, the argument was, my lords, I did not perform even the flexible pavement.
I asked for closure, my lords, of the rigid pavement. And, my lords, the entire reason, my lords, why we are, my lords, at loggerhead today in this litigation, my lords, is because there was an order of termination stating that, my lords, I was not able to achieve 10% of the project financial milestone. Yes. My lords, before, my lords, I get into, my lords, what was argued, my lords, one of the main argument was that, my lords, even considering all things are stated to be true, that, my lords, the road had to be closed, my lords, for rigid pavement. What stopped me, my lords, from performing the flexible pavement work? My lords, what has happened here, my lords, if I may put this into context. My lords, there has been some oversight, my lords, on the part of the respondent department. Perhaps, my lords, it was known, was not known, my lords. In order, my lords, to cover up that oversight, my lords, they kept building up, my lords, in such a way that I could not perform the work. Even before, my lords, my contract was entered into, 80% of the road, my lords, was earmarked by National Highways, the NHAI department, my lords, to execute a 6-lane work, my lords, so widening work in the very same alignment. My lords, may kindly take my brief note for a moment, my lords. I'll refer to the documents and exhibits from there.
Yes.
Lords, I'll go issue wise. My lords, the first issue, my lords, pertained to, my lords, the duration of the contract. Now, my lords, what was argued was, that, my lords, will get, my lords, at the award, issue number 1. My lords, at the page number 132 of the appeal memo, my lords. My lords, there were two, there is something written in numbers in the contract and something written in words in the contract. My lords, what the contract, my lords, is in progression. First milestone is on the 188th day. Second milestone, my lords, is on the 338th day. There are, my lords, fourth milestone is on the 735th day. There, my lords, it's a sequence of events. What the contract says, my lords, at paragraph number 1. Clause number 1.4 is, if there is an ambiguity between what is mentioned in the words and in the number, my lords, what is mentioned in the word should prevail. If, my lords, were to come to the award, my lords, that is what the Learned Arbitral Tribunal also comes to a conclusion at. Stating that, my lords, the reason that therefore is, my lords, 2 years is the contractual period given to me, my lords, for completion of the project. That, my lords, has to commensurate with the milestones. My lords, if there is a 2-year outer limit given to me, my lords, what is milestone 1 has to, my lords, at the end of the day relate to what the 2-year is. My lords, I cannot be expected to do milestone 1, my lords, in 180th day. Then suddenly say that, my lords, the 4th milestone will be on the 335th day, or, my lords, on the 15 month is what they have otherwise claiming. Between 18 month, my lords, and 15 month was the dispute vis-a-vis, my lords, on the completion date. The Learned Tribunal said, as per the contract at 1.4.2, what is mentioned is, in the event of a conflict between what is mentioned in numbers and words will have to prevail. Therefore, the tribunal says 730th day, that is 18 months, so 24 months, I'm sorry, my lords. 2-year period is what, my lords, has to be the completion date. My lords, this also becomes important because of, my lords, the amount of time I had left before, my lords, the order of...
Question is, this contract for what you bid for.
Please.
What was accepted? What was the tender document?
Tender document says 730 days, my lords. My lords, Schedule J, I may take, my lords, through that Schedule J also, has, my lords, both the numbers mentioned. My lords, that forms a part of volume 3, but, my lords, I'll refer from... My lords, may have the convenience compilation that is produced, my lords, by the appellant.
Yes.
That at page number 54, my lords.
Page number 54.
54, my lords, of the convenience compilation of the appellant, my lords, the spirally bound document.
Yes.
My lords, may kindly have project milestone 1, clause number 2.
Yes.
My lords, there are 2 numbers mentioned there. Project milestone 1 shall occur on the 180th, in bracket, my lords, 150th day of the appointed date.
Yes.
Milestone 2, my lords, 365th, in bracket it says 330th day. 3, my lords, is 550, 480th day. And, my lords, completion date should be 650, 730th day. Let's kind of look at the progression. the clause, my lords. It's not a part of the compilation.
No, the question is,
please,
this progression of 150,
please,
330.
Yes.
And
my lords, we look at it, my lords, there is the difficulty there, my lords, is in project milestone 1, my lords, the number is greater than what is there in the word. In number 4, my lords, the word is greater than the number. Milestone 1, my lords, is 180 days. In bracket, it says 150. All the 4 milestone, my lords, 1, 2, and 3, what is mentioned in, my lords, the numbers is greater than what is mentioned in the words inside the bracket. Milestone 4, my lord, says what is mentioned in the words, my lords, in bracket is greater than what is the number provided, that is, my lords, 650.
So 2 are less and 3 are less and 1 is more.
Please, my lords, the progression is what I'm saying, my lords, because the reason why it says 730 days is, my lords, because 2 years is required. My lords, there is a background to that as well. My lords, where the work has to happen, my lords.
If you look at the progression on the other end,
please,
there's no issue.
My lords, there might not be an issue.
180, 365, 550, and 650.
My lords, the reason for that also is, my lords, because where the work has to happen, my lords, one side is a reserved forest, other side is a gorge, my lords, and in monsoon, my lords, this is Shiradi Ghat, my lords, the heart of Shiradi Ghat, my lords, where in monsoon I cannot do any work. That is the reason why, my lords, the contract provides for 730 days.
No, what was bid for?
My lords, bid was for this. This, my lords, is a standard bid document.
That's right. So what is the number of days there?
My lords, it was in bracket 730 and in number 650 minutes. That is what was bid for.
This is not the bid document. This is the agreement.
My lords, the agreement, my lords, KW4.
It was that in your bid documents, when the tender documents were floated, that didn't say to that was 650 days.
Sir, there are certain correspondences where, my lords, the respondent has issued where, my lords, we have said it is 650 days. Because there is that those are, my lords, documented facts.
Not correspondence. The tender is floated. You
lords,
bid for a tender, no?
Yes.
What is the tender condition?
My lords, the bid document, my lords, did not form a part of the records, my lords. The agreement formed a part of the record.
There is no bid document?
No bid document, my lords.
My lords, the tender notification is produced, my lords. It is part of the compilation, my lords.
Is that page number?
Lords, my colleague has the file, my lords. The tender notification is part of the records. And I've referred to in the convenience volume also, my lords.
51
minutes
for
NID.
That's probably what senior is referring to, my lords, is page 51. That is the notice inviting tender.
Yes.
Which says, my lords, 18 months.
Yes.
Yes.
But, my lords, 1.4.2 minutes, I still fall back on that, my lords, because the contract specifies that in the event of, my lords, any conflict between what is mentioned in numbers and in words, what is mentioned in words, my lords, should prevail. I understand that, my lords, there are certain documents where I have said it is 650 at the day, my lords, now, my lords, becomes important because of the termination, the way in which, my lords, the contract came to be terminated. Because, my lords, even though I, my lords, had time for completion of the project, then, my lords, there is a descoping of the work before the termination. Despite that, my lords, stating that I have not achieved the first financial milestone, my lords, the contract comes to be terminated. My lords, 1.4.2 says, my lords, between any value written in numerals and that in words, the latter shall prevail. And let's at page 133, that also is the finding of the learned arbitral tribunal minutes. So 133 minutes, my minutes.
Yeah.
The plea made by the claimant to consider 24 months as the scheduled contract period of 730 days is in accordance with clause 10.3.1 schedule J and clause 1.4.2 F, what Millard suggested out, that in the event of conflict. The tribunal concludes the duration of the performance of the contract is 24 months.
All right.
My lords, now kindly take, my lords, my lords, for a moment I will shift, my lords, to issue number 4, that is, my lords, on the overlapping. Before, my lords, I come to authority engine and RW, my lords, the sequence would, my lords, fall in this way because,
yes,
my lords, overlapping, my lords, is what prevented me from performing the contract. My lords, here is the case, my lords, I asked myself this. My lords, one portion of the contract I was not permitted to work. Because, my lords, there was an overlapping, the department did not, my lords, want for that to become, my lords, public, and then, my lords, dare I say, my lords, oversight, my lords, could come out. My lords, the other portion of the work was rigid payment, my lords, where the contractor before me gets the closure of the road. The contractor after me, my lords, for the very same work gets the closure of the road. I don't get it. My lords, my situation is, my lords, I'm between the rock and a hard place where, my lords, they don't permit me to execute the work where, my lords, I have only given a program that I will finish. The majority component, the financial component of the work, my lords, where I was supposed to get, my lords, closure of the road is not given to me.
No, the argument is,
please,
you can't do the work which for the road that's closed, but where the road is open, what prevented you?
My lords, that is what I'm saying, my lords. For the road which was open, that is the flexible pavement. My lords, what prevented was even before, my lords, my agreement was finalized, NHAI, my lords, had floated a proposal for, my lords, widening the very same work, the very same stretch. 80% of the land, my lords, in October 2016, the very chief engineer, my lords, has an inspection. He records that 80% of the land, of the 90% which was supposed to be given to me, my lords, is with NHAI because they are planning, my lords, additional an expansion of the very same road. So, my lords, the entire, my lords, the argument was on the basis of an oral instruction that, my lords, side stopped the work is what the appellate tribunal concludes that I was prevented because the instructions were oral by the department that don't do flexible pavement. There, my lords, the argument was I did not enter the witness box. My lords, may kindly see the documents. I'll take, my lords, the documents now. My lords, what has happened is, November 2015 is where, my lords, my agreement is entered into.
No,
my lord, please.
If somebody tells you don't do the work,
please.
The first thing you do is to write a letter to him, they will stop you from doing the work, get
My lords,
confirmation.
my lords, it has happened, my lords. In fact, there have been communications. My lords, may kindly take my compilation. My lords, I'll just take, my lords, through those.
Contemporaneous communication, acknowledging that they have been.
My lords, their own documents prove it. My lords, may kindly, my lords, come to the compilation. My lords, may come to page number 12 for a moment, please. My lords, it starts from page number 10.
Yes.
My lords, this is the NHA's, my lords, request for proposal. My lords, may kindly come to page 12, the last table.
Yes.
My lords, as I said, my lords, my agreement is in November 2015, 6th of November 2015. My lord, this RFP is by NHA on 24th of September 2015. My lords, may kindly see, my lords, what is proposed, my lords, may now kindly come back to page number 10. The length, my lords, of what is proposed here.
Yes.
My lords, package number 1, 4-laning of Hassan, existing kilometer 189, design chain so and so to Maranhalli 237. My lords, the kilometers are 189, my lords, to 237. Now, my lords, may kindly see the chart I gave, my lords, on what, my lords, is overlapping. My lords, 216 to 237 for me, my lords, is a flexible pavement. That is the road which, my lords, the appellant has argued that was open, where I could have done the work. My lords, this, my lords, was a tribunal constituted, my lords, of domain experts. All the 3, my lords, retired chief engineers, my lords, from the department. My lords, kindly look at the background, my lords. NHA has called for the work. Now, my lords, the next document, in fact, my lords, the NHA writes to the department saying you also called for the very same work. It is going to be an infructuous expense. Please take a decision. My lords, may kindly come to the next page. My lords, page number 15, if my lords may have. That is, my lords, is the NHA's, my lords, it was exhibit C34 before the tribunal, my lords, the first column. What, my lords, the RFP, my lords, just looked at. The work order was given in March 2017, my lords, for the very same work. This is, my lord.
15 is status as on 31st March.
Please, my lords.
Yes.
My lords, the first entry there is, my lords, the same work which, my lords, just read, the RFP, my lords. For, my lords, 4-laning off from Maranhalli, my lords, the entire stretch, which, my lords, collides with the flexible pavement stretch. March 2016, my lords, the work order has been issued. My lords, it's slightly illegible, my lords. I'll my lords, furnish a typed copy as well.
Okay. Where is the work order for this?
My lords, my lords, award date, my lords, may find it column number 5, my lords. March 2016, my lords, is the award. My lords, the work order was not given to us. This, my lords, was also procured under RTI. March 2016, my lords, the contract was awarded. This is 5 months after, my lords, my agreement comes to be executed.
What is the date here, which is now not legible?
My lords, March 2016. The date, my lords, in March is not mentioned there. Only the month is mentioned, my lords. March of 2016.
What is the start date?
My lords, the start date is March 2017. Date of completion, my lords, is March 2019, my lords.
Yes.
Now, my lords, we come to page number 28. My lords, only for this issue, my lords, the pages are slightly, my lords, arranged. My lords, we come to page number 28.
Yes.
My lords, the NHA, my lords, writes to, my lords, the principal secretary, my lords, the public works department. This is, my lords, August 2014, even before my contract is entered into.
Yes.
My lords, during the meeting held on so-and-so, initiative taken by NHAI for improvement, NH State Wing PWD for improvement of following works in Shiradi Ghat was discussed. My lords, strengthening from providing rigid pavement, and my lords, providing both my work as well as another work. Then, my lords, the next page. It is pertinent to mention that NHA has already proposed for improvement of Shiradi Ghat section with 4-lane configuration, duly undertaking geometric improvements, both horizontal and vertical, along with improvement of curves and hairpin bends. It is understood that NH wing of the state PWD is undertaking the improvement work from 216 to 263 on the existing alignment, whereas NHA is upgrading the subject project with geometric improvements. The expenditure made by Ministry, National Highway Wing, State PWD on existing alignment may be infructuous. It is requested that NH wing of the PWD GOK may take up improvement work correlating with the NHA proposed alignment, such that maximum portion of the improvement now can be utilized by NHA while upgradation.
So where does it say stop work?
My lords, it doesn't say stop work. My lords, the argument was that, my lords, the arbitral tribunal came to a conclusion that, my lords, I was instructed to not do the work there, my lords, oral instructions.
Like on the contrary, it says the maximum portion of the work of the improvement now done can be utilized by NHA.
Please, my lords, may kindly come to the subsequent developments as well, my lords.
Yes.
My lords, may come to now, my lords. My lords, page number 21.
Yes.
My lords, the department, my lords, they themselves, my lords, they are discussing that, my lords, there is an overlap. My lords, may kindly come to page 21. My lords, this is January 2016.
Yeah.
My lords, about 2 months after my agreement. My lords, ministry in the letter dated so-and-so has accorded administrative approval. My lords, may come to the third paragraph. My lords, in the meanwhile, the project director NHAI Bangalore in the letter dated so-and-so addressed to the chief engineer National Highways Bangalore has informed the status of the upgradation widening work of Hassan to BC section in the respect of package 1 and 2. And package 2 covers part of the work of strengthening from kilometer so-and-so 216 to 237 and providing rigid pavement from Kempohole to Addahole, Shiradi Ghat under EPC mode. NHAI package, 4-laning of Hassan Bantwal section, chainage so-and-so to so-and-so, NHAI package number 2. It is informed that for the above package, the bidding process has been initiated and the last date of bidding is 22/12/2015 and the process of approval of 3G for which award is in progress and is expected that 90% possession of the land would be available by 31/3/2016 and the proposal for diversion of the forest land for an extent of 33 hectares has been forwarded for RO MOEF duly recommended by GOK, which requires clearance from MOEF and it is expected to take longer period. And under package 1, a bypass to Sakleshpur town has been proposed from existing 219 to 226. Since rigid pavement is proposed, the strengthening work from existing 216 to 219 and from existing 225 to 237 on either side of the Sakleshpur bypass would not be utilized by NHAI. Also, NHAI has designed the alignment by improving horizontal and vertical geometry, hence it will not be possible to utilize the existing surface. My lords, the para after. My lords, here again, my lords, kindly see, my lords, what is left. What is left, my lords, is the Sakleshpur bypass, which, my lords, I was told to work. I have completed the work. It is an admitted position. 6.06 kilometers, my lords, there is no dispute vis-a-vis the quality or the quantity of the work. That is the bypass, which, my lords, is excluded from the NHAI's acquisition. The NHAI's proposed development. My lords, the para after the para, my lords, is straight. In the meanwhile, the ministry in the letter dated so and so, dated 17/11/15, has noted that the ministry during the year 2014-15 has sanctioned the above work and the state government has invited tenders.